Good morning, sir. You're Corey Flemings.
Yes, ma'am.
And Mr. Flemings has two cases, 24 DCCR 2144 and 2145, set for trial to begin with jury selection next Monday. What is the announcement?
Judge, we're ready, subject to a ruling on my motion to quash the enhancement portion of the indictment.
State's ready to proceed.
I would ask which case Mr. Coleman intends to try first.
We intend to try the assault on the peace officer, Judge, and put on punishment evidence pursuant to a notice of extraneous offense of the injury to the disabled person.
And so the enhancement portion wouldn't change anything other than potential punishment?
Yes, ma'am. It would require you to declare a penal code statute unconstitutional.
Oh. That would be novel for me.
Yes, I figured it was. I have a case pending in the 9th right now with the same issue.
So hold on a second, let me look at the indictment. Is the enhancement alleged? Yeah, so it's alleged in the indictment, and so I would need to make that ruling prior to jury selection.
Yes, ma'am.
So that, well, we don't talk about punishment range in the jury selection. We'll talk about it. I'll get the case numbered. And then if it's numbered 1, we'll handle it either prior to or just after jury selection, because it won't change anything that you say in voir
I
dire.
think that if the punishment range is 25 to 99 and he is convicted and goes to the jury for punishment, I do believe I get to voir dire on the potential range of punishment.
And if he gets to voir dire on it, certainly the state would ask for reciprocity on that.
I don't have a problem with that.
Well, here's how I handled any enhancements on punishment and how I would intend to handle it is I do not go into specifics or allow you guys to go into specifics. I will, in my part of talking to the jury, explain that there are different circumstances that could lead to higher punishments or lower punishments depending on the evidence that's presented. But getting into specific, especially priors, if I'm going to make some ruling potentially that they're not admissible or that we're not going to get to until punishment, we're not going to get into that on guilt innocence. We're not going to get into it on voir dire very specifically, other than if there's something, because if you allude to it too much, I think you're putting yourself and your defendant in a position where you're telling a jury up front that he has potential criminal history that could go into their decision-making in guilt innocence. So
Yes, ma'am.
we're not going into that. I'll say what I say, but as far as spending a lot of time on it, that's not going to be an issue during voir dire. I'm not going to allow it to be one, but I will make the ruling that day so that we know before we get started. If it's going to change anything about the status of trial, and if I deny it, y'all want to renegotiate, or if I grant it, then let me know that. If you think it'll change anything, then I can make that, we can get something done either later today or tomorrow. I'll take a look at it so that you know ahead of time, because I want to know that, if I deny the motion to quash, which it sounds like I likely am not going to find our penal code section unconstitutional. If that changes Mr. Fleming's position, y'all talk about that today, because I want to know that if there's going to be some type of negotiation and a plea, I want that done today.
Yes, ma'am.
Okay?
Court's information, regardless of how the court rules, the state's prepared and willing to proceed with trial.
Yeah, no, it's gonna be numbered, and we're running low on, the number 1 just pled this morning, and so it's likely this could go. So I want talk to Mr. Flemings. I've looked at the motion to quash. If y'all want to talk about it real quick, I can let you make your argument at this point.
I think we already talked about it.
I think we did. And so, I can go ahead at this point and deny that motion to quash that you filed. And so that way, we've talked about it. I've read the state's brief. I've read what you filed, which had your information in it. And so that being done, y'all, if y'all want to talk, if that changes anything.
Yes, ma'am.
Okay, so do you want me to hold it while y'all visit? or-
I've got a meeting I've got to go to. I will visit with him, and then if it's going to be a plea, I will advise the court.
No, it's going to plea today.
Yes,
And y'all
ma'am.
need to talk now
Yes,
or
ma'am.
before docket's over.
Yes, ma'am.
Okay, I'll hold it.
All right.
I need the DA to sign that, please. Okay. All right, again, you are Corey Flemings, right? And will your client waive the formal reading of the indictment?
Yes, ma'am.
And we are going forward just in 2144, right?
Yes,
Yes,
ma'am.
Judge, and the state's waiving the punishment enhancements.
Thank you. Let me get that pulled up properly. And he'll waive the formal reading.
Yes, ma'am.
Mr. Flemings, in cause number 24, DCCR 2144, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer from September 11th of 2024, and how do you plead to that charge? Are you,
If I may, I think I marked that it was the third on the plea papers. If we could change that to the second.
we'll get that done, thanks. All right, so I'm making that modification to second degree with everyone's permission.
Yes, ma'am.
Yes, ma'am.
And so how do you plead again to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Flemings is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of that agreement in cause number 24, DCCR 2145. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge. May I
Thank
be
you.
excused?
Yes, thank you, sir. Robert Trahan. And Mr. Trahan has 3 cases, 25 DCCR 1094, 1317, and 1536. Mr. Eckhart, sounds like you have been working on the case but need a little more time. Is that correct?
I do, Judge. I have discovery, I have media, but I'm still going through everything to try and see if there's something we can work out with Mr. Coleman.
Okay.
I think by the next setting, we will be able to tell the court what direction all this is headed.
Okay, any issues?
No, Judge, the state's not opposed.
All right, I'm just going to reset your case. When we're reset, Mr. Eckhart will be out there to visit with you about everything he has, and we'll see if we can get an announcement the next court date. All right, you can go back with the bailiff. See, nope. Mr. Parker, you have Jason Jones.
He's one to request hearings, I guess we just go through the motion.
Okay, thanks. Good morning, sir. Are you Jason Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And so, Mr. Jones, in cause number 23, DCCR 0390, I have a motion to revoke your community supervision. Shows that you were placed on probation June 2nd of 2025 for the third-degree felony offense of unlawful possession of a firearm by felon, and that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you were arrested for, state wish to do anything with that wording?
I would like to amend it to say.
Y'all gotta go through all
committed
these.
the offense of.
On counts 1 and 2?
Yes, Your Honor.
Any,
I have no objection, but also point out, I assume the date is wrong on number 3.
That's correct. It should read June. Count 3.
This is filed July 3rd.
yeah, probably, I'll print it. I need y'all to go through all these motions for the arrested language and change those.
Kelly, do we have an idea when it started?
I'm sorry.
When it started?
She has no
reading
idea.
Okay.
The MTRPs say arrested for instead of, y'all's people write them, so I don't know when they started doing that, or who, if it changed up there, if
Probably
somebody
because-
changed that did that.
Well, we're in third secretary office.
Okay.
You know, a little over a year, so yeah.
They need to, somebody needs to make it their job to go back through all of them. Maybe at least for that year. It seems like it's been an issue.
I think so.
Okay,
But what I'd like to amend, Your Honor, is take out was arrested for and put committed. So read committed the offense of.
and that's on 1 and 2. Any objection to that change in counts 1 and 2?
No, Your Honor.
And then in count 3,
The date should read June 21st, 2025.
any objection to that amendment? All right, made those changes and grant all of that. Okay, so count 1 in the motion alleges that you violated your probation by committing the offense of possession of a controlled substance June 21st of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 alleges that you committed the offense of possession of a controlled substance. So the first one is penalty group 1-1/1B. Count 2 is that you committed the offense of possession of a controlled substance, penalty group 2A. And is that true or not true?
Not true.
And then count 3 alleges that you possessed a drug, marijuana, synthetic marijuana, and crack cocaine on June 21st of 2025. And is that true or not true?
Not true.
And then count 4 alleges that you failed to stay away from locations considered high crime areas by being arrested by BPD on June 21st of 2025 in a high drug trafficking area with various illegal substances in your possession. Is that true or not true?
Not true.
All right, so what we'll do, I'll enter pleas of not true to counts 1 through 4. We will reset this for a hearing. How long would you anticipate? I'm assuming you'll need lab and,
Judge, the substances have been sent off to an independent lab to expedite testing that's currently in their possession being tested. I made that request early December, so I expect it to be back before we have a hearing.
okay, we'll reset it for a hearing. I'll get an updated pre-sentence report. And as soon as obviously you get any of that information, get it to Mr. Parker. We'll set it for maybe a day where we have a little longer than just an 11 o'clock. We'll set it where we have time for officers and whatever we need.
Thank you.
Okay?
Thank you, Judge.
All right, you can go back with the bailiff.